To be here and to meet all of you and to see you again, Representative Troiano. My name is Lisa Warren, and I'm pleased to be here tonight before all of you. Before my appointment as a judicial officer in 2019, I proudly served as the Caledonia County State's Attorney for about 10 years, excuse me, and prior to that as a Deputy State's Attorney for about 4 years, handling juvenile cases, chins and delinquency matters, misdemeanor crimes and felony crimes, including multiple homicide cases, sexual assaults, domestic assaults, and many other offenses. I was simultaneously honored and humbled to perform my duties as a public servant in my county. I was a founding member of the Special Investigation Unit that served Caledonia County, working with various stakeholders in the community to prosecute and best serve sexual assault victims and crimes against children. And I served as president of the SIU for several years until I was appointed. In October of 2019, I was honored to be sworn in by Governor Scott as a Superior Court judge. After being sworn in, I completed several weeks of training with the Vermont judiciary by shadowing different judges in the state in their courtrooms and completing numerous educational trainings taught by seasoned judges. Additionally, I attended virtual trainings that over several weeks designed for new judges through the National Judicial College. My initial judicial assignment was in the domestic and juvenile dockets in Windsor County, which began in December 2019 and went until August of 2021. I was fortunate to serve in Windsor County with other judges who had lots of experience and who graciously mentored me and were willing to discuss matters as they arose. As is customary after appointment, I was also assigned a mentor judge who has been extremely helpful helping me acclimate to the bench and is someone I still consult with occasionally. While I was excited and nervous initially, I very much appreciated my first assignment in the domestic and juvenile dockets, which distanced me from prosecution and the criminal law. I had not represented clients in domestic cases or juvenile cases in several years. While I handled juvenile cases as a prosecutor, my primary caseload was in the criminal docket. I saw that as a good experience or opportunity to put the training I had received in conjunction with my 24 years of experience as an attorney to work. As you can imagine, serving as a judge involves a big learning curve. And as if the learning curve is not enough of a challenge, shortly after my arrival in Windsor County in December, the new judiciary case management system, Odyssey, was introduced in Windsor, Orange, and Windham counties. And on the heels of that, the pandemic struck in March, which shut the judiciary system down for in-person hearings almost immediately. Fortunately, WebEx became available for hearings so attorneys and parties could appear remotely. I continue to preside over my hearings in person and virtually because I found that being in court with a judicial assistant and other colleagues seemed to boost morale in a challenging time when everybody was isolated. Virtual hearings can be difficult due to connectivity issues. However, I discovered that attendance for hearings was very good, especially in the juvenile docket, because most litigants had phones or devices capable of joining by WebEx, whereas not all litigants had reliable transportation to attend court hearings. Even though hearings were primarily conducted remotely during my entire first 2-year rotation, I was able to keep the juvenile and domestic dockets flowing to get cases disposed of in reasonable timeframes. However, our courtroom time changed and was shortened during the pandemic to approximately 5 hours per day. Remote hearings also proved challenging in maintaining the integrity and decorum of the virtual courtroom. So in addition to trying to keep the docket running on time and ensuring participants had their day in court, I would need to address and still need to address other issues in the virtual courtroom, such as asking participants to put their video on during hearings, advising participants to extinguish cigarettes or vaping devices, and ensuring participants' focus was on the hearing and not on what was occurring in their home or location. It's tough, if not impossible, to see everything that goes on in the live courtroom and on the WebEx all at the same time, particularly if there are multiple people in court and multiple people on the WebEx. Certainly, I welcome feedback from attorneys or anybody in court, including security officers, that notice anything amiss in the courtroom or in the virtual courtroom. Even before the courts formally reopened for in-person hearings, I began attending my hearings in person as a rule and virtually by exception, with masking and other precautions in place. There were occasions when I worked remotely on findings days if I was drafting decisions, and for emergency hearings on those days, I would participate by WebEx. From September of 2021 through August of 2023, I served as the presiding judge in Orleans County. I was responsible for the criminal docket and family court docket, which addressed parentage, dissolution cases, modification of parental rights and responsibilities, and parent-child contact. Both dockets were extremely busy and backlogged, which was a statewide issue following the pandemic. Soon after my arrival, we were able to resume jury trials in the county, which were halted due to the pandemic for about 18 months. And Orleans County was one of the last counties in the state to resume jury trials due to the insufficiency of the HVAC system. Early on, in October of 2021, we had a plan to resume trials in another county that had sufficient HVAC because we had speedy trial demands that I needed to address. No trials actually occurred in other counties because cases settled during those months when we were planning to go to a different county and the HVAC issues were addressed. Once trials resumed in Orleans County, I believe it was January of 2022, we had a jury trial and sometimes two nearly every month after. I placed a lot of cases on the pretrial and jury trial list, somewhere between 30 and 50, as my colleagues did in other counties, because some cases were 3, 4, and 5 years old, and I had to consider incarcerated defendants and speedy trial demands. At the end of my 24-month assignment there, my overall clearance rate was just under 100% at 99% in the criminal docket and over 100% in the family court dockets, which means that we were clearing out cases on a good level. In September of 2023, I was assigned to Windsor County again, and I'm responsible there for the family court docket, parentage, dissolution, modification hearings, the relief from abuse docket, and the juvenile docket. I currently serve as a member and the chair of the Family Division Oversight Committee, and I'm serving a 2-year position there that I've held since September of 2022. That committee is responsible for holding regular meetings to discuss changes to court forms, family statutes and rules, improvements to family division policy, and other such matters. As a Superior Court judge, I am committed to upholding the rule of law for all who come before me. My goal every day on the bench is to ensure that parties have their day in court, that they feel and believe they have been heard, that I will rule based on the evidence and not on my feelings and perceptions. I do not rush through important matters. My changes of plea with defendants take time, and it is not an area that should be rushed. It is my obligation to ensure a defendant wants to enter a change of plea, is doing so voluntarily, and understands the ramifications of doing so. I pride myself on how I run my courtroom. I conduct structured hearings and start promptly because every case is important. I begin each hearing by announcing the name of the case and the case number and introducing the attorneys by name, Attorney Jones, for instance, and parties by proper names too. I then review the nature of the hearing and issues that are to be addressed to ensure that everyone is on the same page. I ask the attorneys or parties if they are in agreement with my assessment. If I have unrepresented parties in court, I further explain how the hearing will be conducted, that the plaintiff or movement presents evidence first, followed by the other party. And I explain that I will conduct the questioning when parties are pro se, and if the other party has any questions after I question the witness, the other party, then they can tell me what those questions are and I'll ask them. And I ensure them that both sides can tell their side of the story. In each court, I have regularly consulted with the court operations managers on ways to keep dockets moving forward. I also held regular bench bar meetings in each docket in each court to share and exchange information and ideas with the bar and other stakeholders. Sadly, in both counties where I have sat, I've seen across the dockets a number of litigants suffering from significant opiate dependency and misuse and/or alcoholism, often accompanied by co-occurring mental health disorders. Unfortunately, there was no treatment court in Orleans County. Windsor County is fortunate to have a DUI treatment court for defendants to participate in if they meet certain criteria and wish to do so. Nevertheless, for defendants suffering from substance use disorder and or mental health issues, I've issued many pretrial monitor orders when I was in criminal court and authorized defendants to be released from jail to complete treatment at facilities such as Valley Vista. During my initial judicial training after being appointed, I observed 2 judges conduct their respective drug treatment courts, and I have covered the DUI treatment court one time for the assigned judge, Elizabeth Mann, and I will be covering it again tomorrow because she had a commitment. When I was a prosecutor in Caledonia County, we were fortunate to run a family treatment court and juvenile court for parents struggling with drug and alcohol issues, as well as mental health, housing, and in other areas. I was an active member of the treatment court team for several years. We met regularly to staff the cases and hold meetings with the participants. The family treatment court there ran for about 14 or 15 years, but unfortunately is no longer in existence. The treatment court model is one which I firmly believe should be offered in every county of the state, which would require buy-in in each county from the attorneys, treatment providers, and other community stakeholders. I do not believe such courts can be regional because of challenges such as transportation and homelessness. Hopefully more headway can be made in this area to address the opiate crisis, alcoholism, and mental health conditions plaguing our citizens. Overall, I am pleased with the retention survey results. I have reviewed the comments provided from the surveys multiple times. I respect the comments offered by attorneys and judiciary staff alike, and I accept others' opinions of me as a judge. I take these comments and concerns seriously and to heart. Since reading in them, I've engaged in self-analysis and a paradigm shift, putting myself in the place of those making the comments. And by doing so, I've realized that while I may have thought I was conveying one message, it was received differently on the other end. This causes me to more closely consider my rulings, my remarks, and my demeanor moving forward. From the time of my appointment, and as recently as reading the survey results, I realized that being a former prosecutor would likely raise issues and concerns from both sides of the courtroom and criminal court about bias. I've been sensitive and acutely aware of this perception from both sides and appreciate the comments. It bothers me that I made someone cry, and I am sorry for that. It also bothers me that I've been perceived as favoring a certain sex over another. I recall later in my career as a prosecutor, after trying a case against a young defense attorney, she thanked me for treating her fairly and kindly and respectfully, I believe those were her words, during trial. I think I responded that she didn't need to thank me, that just because we were on different sides of the courtroom, it did not mean we cannot be professional and cordial. I've always undertaken to be a positive influence for younger colleagues in the legal profession, especially younger women, establishing themselves in the field. I was pleased to read the statement from one of the judiciary employees who stated that I was a strong woman. My goal as a judge is to ensure that both the prosecution and defense in criminal cases, the state, parents and children in juvenile matters, and the plaintiff and the defendant in the domestic and RFA dockets not only feel like they each had their day in court, but believe that they have had their day in court and have been heard in a fair and just manner without bias to anyone for any reason. I've attended trainings on bias as recently as this past summer in our judicial training. One issue that frequently arises in criminal matters is the demand for a speedy trial. The state and public defender's offices are staffed differently, at least in the smaller counties like Orleans, where the state may have 4 or 5 attorneys. The public defender may have only 2 attorneys, and they may have the bulk of the cases on for a draw. I am aware of the survey comment that indicated I challenged the state on jury draw day, excuse me, on whether its attorney was truly ill, but took at face value in a previous month that the defense attorney was sick. First, I did not intend to in any way to suggest that I questioned the veracity of the attorney, who was in the same building with the jurors, defendants, defense attorneys, and judiciary staff on the date of jury draw. Nor do I believe did I request a positive COVID test. Because I was faced in that case with a defendant's demand for a speedy trial, I did not think it was unreasonable to request that another attorney for the state handle the jury draw because the trial date wasn't for another week and the case was a misdemeanor. I will certainly be more cognizant in the future of ensuring that both sides believe they are treated fairly. I do start my dockets on time because everyone's time is important, not just the court's time. Attorneys often have multiple dockets running, sometimes in multiple courts to attend to. And litigants often have personal demands they need to meet outside of court. When I had incarcerated defendants calling in on WebEx from a jail, I needed to adhere strictly to the schedule because the facilities had cutoff times for WebEx hearings. So I needed to accommodate that schedule. I have called cases on a few occasions when parties or attorneys were not present for hearings at the scheduled time, even if they were in the same building. I will be very mindful of this going forward and allow some latitude. In managing a timely docket and a busy docket, however, I need to ensure a snowball effect does not occur whereby one hearing delays another and so on. I dealt with the backlog in Orleans County as best as I could, as each of my colleagues did statewide. When I arrived there in September 2021, the family court was understaffed and there was only one criminal court judicial assistant, a severe shortage for such an overwhelmed docket. Having only one criminal court judicial assistant severely impacted the ability to schedule criminal hearings regularly because she could not complete her work at her desk that needed attention and record and docket hearings in the courtroom. I do not offer this as an excuse. I am merely offering it to show perspective and context, because it is not just me in the courtroom. Fortunately, the staffing levels have changed in both courts over time. I've worked hard in both counties in all dockets to treat all attorneys, litigants, and witnesses fairly and respectfully by properly addressing them in court and permitting each person the proper time to present evidence and/or argument. I ask each side how much time they believe they need for presentation of evidence so that sufficient time is set. I'm mindful to ensure that parties receive fair amounts of time, and in that vein, I record the time that each side uses in hearings and frequently will let the parties know how much time they've used and how much they have left. I will be sure to check myself on allotting fair amounts of time. I was pleased to read the comment that an attorney wrote that stated that while the attorney may have disagreed with my rulings, sometimes the attorney stated, "I'm not biased in favor of the state, and my rulings are a legitimate exercise of my discretion." I realize and appreciate that my decisions are not going to please both parties in a case, and one side is inevitably going to be less happy than the other. That is the nature of the adversarial system. As judges, we deal with people usually at very low points in their lives, facing criminal charges, having their children placed in state custody, divorcing a spouse, and disagreeing over parental rights and responsibilities and property, or participating in a relief from abuse action. A decision that does not go a person's way when he or she is already low will not be received well, and I can appreciate that. I strive to apply the law and rules of evidence, regardless of who is before me, fairly and appropriately. I understand there are comments that suggest I have not done so. I take these comments seriously and will continue to work every day to be a better judge than I was the day before, both procedurally and personally. I continuously attend trainings on substantive and procedural law as a judge, including the judicial trainings offered in-state and trainings offered by the National Judicial College. And on the job, not a day goes by when I don't learn something new, and that is one aspect of this job that I love. I don't purport to know everything. I never have as a judge, nor did I in my previous career. As a wise attorney once told me, a smart attorney doesn't know all the answers. A smart attorney knows where to find the answers. I apply this adage in my work as a judge. I'm fully committed to attending all judicial trainings offered to improve as a judge and to incorporate feedback that I receive. While I do not wear my emotions on my sleeve in the courtroom, it is significant to note that as a judicial officer, I often finish the day taking home a mixed bag of emotions. This is particularly true in the juvenile docket, but it applies in the family docket and criminal docket as well, because I'm dealing with people with critical needs, sometimes substance abuse, sometimes mental health, sometimes homelessness, breaking the law, etc., whose lives are turned upside down and who are in court because of those needs and that upside down state. I'm cognizant that I've been perceived as cold or unsympathetic by some participants in court. I take great pride in acknowledging parties who are struggling with substance abuse and/or mental health issues, for instance, who have attended treatment or who are following a treatment plan, offering encouragement and support to them. In one case recently, after offering accolades, parents' accolades for their months of sobriety and addressing concerns that led to court involvement, one parent was visibly tearful and the other parent thanked me for saying what I said and meant to them. Very often when I offer such comments and positive affirmations, the recipients are thankful. Serving as a Superior Court judge is a privilege and a very fulfilling experience for me. I enjoy bringing thoughtful resolution to litigants who have waited substantial periods of time for their day in court, while simultaneously seeing the humanity of each case. I look forward to affording all persons their day in court with fairness and respect, and I will strive to improve in all aspects as a judicial officer, and I respectfully seek retention.
Thank you for your testimony. You've addressed the questions I was going to raise, but can you go into any more detail on how you plan to deal what you have acknowledged were some problems?
I think a good first step is perhaps pausing and thinking about a reaction or a statement before making it. As we've heard today, and we all experience, the dockets flow fast, and sometimes there are lots of cases on, and sometimes we may say something that may have come out not the way we meant it or in a tone we didn't mean. And I think pausing and reflecting, even briefly before saying something, could be helpful to think about before speaking. I certainly am more than willing to reflect on the training that I've received and training that I want to receive, and have some recommendations on stuff going forward. I've taken full advantage, with the exception of one training that I missed due to an injury. I've taken full advantage of all the in-state training and National Judicial College, which was excellent training as well. And so I just plan to take all of this feedback that I've learned here to heart, to listen to it. I can read this again to remind myself what I want to work on. I will absolutely consider these comments. They really are eye-opening. And other thing that I know I'm going to do, if retained, is I want to get the midterm surveys so I don't have to wait 6 years. I think that could be helpful. This is my first retention. I was just appointed just a little over 4 years ago. So that would be very helpful, I think, to get a kind of a gauge midterm. So I'm definitely going to take advantage of that. But this is a good check and a good thing to refresh with.
I do want to express sympathy for the difficulty you had with the remote hearings. COVID made mincemeat of a lot of people.
Yeah.
There was a Canadian parliamentarian who stepped out of the shower after a run, not realizing that they were in session. He was formally reprimanded for violating the rule that gentlemen wear neckties.
That's all.
So, we will start with Representative Oliver and we'll proceed in clockwise.
Thank you for being here. I was trying to remember exactly what cases I had seen in front of you. Not many. We've had only a couple cases in front of you. And you can comment on this if you like. But my impression being in the courtroom is that the judgments that you made were actually in favor of the defense, because I had circled favors prosecution, bias towards prosecution, and I didn't see that. However, I saw what appeared to be fair. The thing that I did notice was you were right, and you addressed it. You don't wear your heart on your sleeve. You came in and you ran that courtroom exactly as you expressed from your notes. It was very by the numbers, on time, rigid, I would say, and like clockwork. But yes, I did not see any emotion whatsoever, really, and you can run with that, I guess.
Well, I think I am a very emotional person, actually, in my personal life. But I think it's tricky in the courtroom, because, especially in a criminal court, but also even in a family court context, because we are impartial arbiters. We can't favor one side over the other. It would be absolutely easy to feel badly for a litigant because of what he or she or they have been through. and internalize it and break down in tears. I mean, we're all human. That's why we take breaks sometimes, because we need to, compose ourselves. But I had a case the other day that was gut wrenching that I could have just sobbed about, involving a juvenile matter. And I think it's just, what I need to do is I either need to take a brief recess so that I can compose myself, because wearing a poker face can be tricky, or I just need to swallow a few times, take a couple sips of water, take a step back, and then, ask for the next person's questions or whatever. But it's tricky because we just can't show any partiality to any party, even victims. And I am sensitive to victims. I was a prosecutor for about 14 years and worked with many victims through the SIU, including victims in homicide and sexual assault and aggravated domestic assault cases. So I am sensitive to that. And I know there was a comment that suggested I didn't appear sensitive to victims and their needs. And I respect that comment. That is a perception that I respect. But as a judge, I have to appear impartial and fair. And that's why I try to treat everybody fairly, respectfully, and with all due respect around the courtroom, not showing favoritism. I hope that answers.
Yeah, thank you. It certainly sheds light on it.
Thank you, Mr. Chair. So welcome, Judge.
Thank you.
We've already talked a lot about this. Both the chair and the vice chair have made comments. I just want to know that, again, you did read, obviously, what some of the comments were. And we quite often note, and I guess to varying degrees, we take this into consideration when we make our final decision, especially about bias tendencies. For the most part, they seem to offset each other in many ways. Representative Troiano mentioned a swimming score or something, which I thought was a pretty good analogy
Diving.
myself. Or diving, yeah. But again, they're balanced one way or the other. And for many of us, they sort of cancel each other out to some degree. But there was one rather strident comment that came from the person who, well, it was the lengthiest response that we saw from one of the attorneys. And I can read the part that I found particularly strident, if you will, or you could just sort of take a look at that yourself and answer it. Because again, I want to say the attorney seemed to be in one place with you in terms of performance. And I do want to note that the court staff, the assistant judges, and all the non-attorneys were very all positive. So that sort of separated things for me as well. It's a tough thing. It must be a tough thing to read some of these comments and not feel badly about them. So I'll just give you a chance to answer whatever. I mean, that was a very long comment.
Yes. No, it was. And it seemed like it was an exam report on everything that was perceived as unjust or incorrect that I did wrong during my term up in Orleans County. And I respect the comments. I respect the person's perceptions and their feelings of how I did. They've opened my eyes, the comments. I may not necessarily agree with them all, but I certainly have looked at them repeatedly. I've read these over multiple times, including today before I came over here today. Again, because I do respect people's input. And I just think that the person was trying to get everything out that the person wanted to on paper. This is a forum to do it in, albeit anonymously. As Judge Treadwell had said earlier, we don't get feedback from attorneys, except the midterm ones that I now will definitely take advantage of. So this is their way to do it. And from that one, it looks pretty negative, with the exception of I do not lack integrity or sincerity. I will not have the bottoms. I take pride in that. And I do take pride in my integrity and sincerity very highly. I value that a lot. So again, all I can say is that I respect the comments. I may not agree with them all, but they are eye-opening and sobering. And I will, again, keep this as a manual going forward.
I'll note, I don't know whether this person took a survey, but to say something like the bar as a whole, I don't know how you could answer for the whole bar without talking to every individual lawyer. So again, I take it for what it is and move on.
Well, I saw that and that was concerning actually as well. But when I looked at the actual survey results, it showed more, 86.21%, which is 25, if I'm doing my math correctly, out of 29 of the attorneys think I should be retained. And I think it was just under 3.9%. So we'll call it 4 attorneys didn't think I should be retained. I felt good about that. I mean, it's not a perfect score. I know this process rarely yields a perfect score. I know it does sometimes, and I respect that. But this is a growing experience for me. So to say that the whole bar, when I didn't approve of me when I see the bar graph, I couldn't equalize that either, but I'll just keep trying every day.
Travel.
Thank you, and thank you, Judge, for being here. In full disclosure, I'll admit that I've known Judge Warren since she was a teenager over in St. John's, Missouri. And that's not a lie, that's truth. So, and I also worked with you with the judge for all 14 years, where you were the deputy prosecutor and the prosecutor. And my experience, I have to say, was that you were fair, that you didn't have any extreme dogma of any type. And we were able to really communicate and come to very fair results, I have to say, in the 5 or 6 prosecutors that I worked with in my 35 years, that you were very not easy to deal with, but righteously to deal with. I mean, we always came to good conclusions, and I appreciate that. And feedback that I've heard from some of my connections in the courts that you are fair, and that you, in fact, one report was that that prosecutors thought you were too fair to the defendant or too biased toward the defense. Of course, that would be okay with me, but so again, it's a little difficult to weigh these things. Knowing you personally has led me to believe that you, as well as all judges that are appointed to the bench, want to do a good job. It is a prestigious job. It elevates you in your position in the community and in the state of Vermont. And my belief is that all judges that are appointed want to do a good job, and I certainly believe that of you, Judge Warren. And I don't think I need to go into any of the scores or any of the comments or anything of that nature. I did agree with your decision on the 48B motion that that you ruled in favor of. Those are pretty hard to win.
Yes, well, I had a number of them too with the COVID.
Yeah.
Number of litigants filing for a dismissal under Rule 48 in the interest of justice. And some of them were granted and some of them weren't. And that's what they should be filing,
Understood.
So
Understood.
thank you.
And I also just to wrap it up is that seems like some folks in these comments blamed you for the backlog in the court, and we all know here in this room, particularly, that that's really not the case, because I think it was Magistrate Peterson that had commented on staff shortages and difficult times in the courtroom really precipitated these things and made them actually work. So, again, that's nothing that I would blame you for. So, thank you.
Thank you.
Thanks for being here and for your great comments, and for seemingly taking seriously some of the criticisms that we read in the surveys. I have one area where I see a conflict or sort of a dichotomy between what I hear about your demeanor and what an improvement that was suggested by someone who responded to the survey. So I hear cold, rigid, don't wear your heart on your sleeve, which to me suggests, someone who's strong and in control. And then one comment that suggested a very specific improvement, which says improvement is needed in having more confidence to take control of the courtroom and promote efficiency and make bolder decisions that do so. I'm wondering if you could just speak to what I see anyway as a little bit of a conflict there.
I did see that comment and appreciated that one as well. Get to it here. Yeah, I didn't know what to make of it because it was kind of a split comment. I value the improvement comment. I absolutely believe I can improve. I try to improve every day. I'm a perfectionist and I have a little bit of OCD. So I absolutely took that comment to heart on the improvement piece and I try to take control of the docket. It's really hard managing a courtroom without COVID and without the pandemic, the WebEx, in a regular courtroom with people all before you. And then you multiply that difficulty times 5, I would say, with WebEx, because then you've got to make sure there's connectivity issues that are being addressed, and you've got to make sure people are in the courtroom, that cases are being called, and you've got to run on time, and you've got a number of cases on, and every one of them is important. Not one is more important than the other. And it's very, very tricky. And it's something I work on all the time. And I do run a rigid schedule when as much as I can. And sometimes things get in the way, like lateness to court or connectivity issues if it's WebEx or people talking, resolution. And I respect that. But if that's happening, it may make a case run late, which may make the next case run late and so on. So I do need to probably rein in that a little bit better and maybe, propose, well, do you want a continuance? And we'll take your case right off if you don't want your case heard that day. And then there was some further comments down about hesitancy to make decisions. And I'm not certain what that was about, other than maybe making more even-keeled decisions for defendants in cases is what I interpreted it as based on the context of the sentence. I did make some decisions later in my tenure that I did rule in the favor of a couple of defendants, and I imagine that's why that comment was received well. It further noted, though, that it appeared I was tied to law enforcement and prosecution. And I think that's going to be a common theme just because I came from a prosecution background. But then there are prosecutors or what look like prosecutor statements that say I look to be defense biased. So I don't know what to make of that, other than if there was a decision made in that particular case, that may be why I was perceived as pro-prosecution or pro-defense because of how I ruled. That's not the case. From my perspective, I rule how I believe the law leads me and what the facts show to me. But I respect the perception of it. And I like the end of that comment, though I will say that the person thought I had integrity and a stronger knowledge of law and procedure than those that have presided longer, as well as those of equal tenure. So I was very pleased to read that. And I absolutely appreciated the comment further above about improvement, taking control of the courtroom. I thought I had pretty good control, but I will obviously try to take more control over it. Hope that answers.
Yeah, it does. Thank you. Helps me a little bit. Yeah.
Thank you. Senator Harder.
Thank you, Mr. Chair. Thank you, Judge Warren, for being here. I have a few questions. The chair will indulge me. First, when I read your file, I wrote down, where did she go to law school? And then I Googled you and found a different bio of you and realized that you read for the law. Okay, that was not clear in your file, or at least not to me. So just next time, maybe talk about that a little bit more, because I think it's an interesting route. We actually just had a senator that got admitted to the bar after reading for it. And so I guess one of my questions is, do you feel like that experience prepared you well enough for your positions, both as a prosecutor and now as a judge? So that's why I'll just give you all the questions that you can address as you want. I was a little underwhelmed by the cases you chose as people on the committee know, I really love to read all the cases and ask a lot of questions about them. And 2 divorce cases and then a sort of dismissal case. So I'm curious why you chose them and what you were trying to tell us by choosing those as your record for the committee. And then the third question I had was your answer to what I think is a really important question about the concept of equal justice. It's broad, it encompasses many things, encompasses many things. What measures have you taken? There's a longer part to it, but the measures you've taken to provide equal justice. And what could the legislature do to support? And mostly your answer was sort of like administrative procedures, like about WebEx and things like that. And so I was a little underwhelmed by that. And so I was hoping you could expand on sort of your more philosophical view of access to justice and so I can get a better sense of that.
All right, so I'll start chronologically with your first question.
Okay.
Do I think that my experience clerking for the bar properly trained me? Yes, I do. As with any couple of sets of experiences, I think there's pros and cons to various scenarios. So I didn't go to law school. I learned by working in a law office for 4 years and going to court most days, maybe not every day, but 3 or 4 days a week with the attorney that I worked under. And I did assignments in the office and I did title searches and research and things like that. I learned very early on, and it was really interesting to see how to properly admit a piece of evidence by being in court with the attorney and by seeing how it was done, that you mark your exhibit, and you offer it, and you show it to the person and so forth. So I learned that I think that, was definitely a leg up from what a law school evidence course might focus on. There's downfalls, there's, or not downfalls, but there's pros and cons to each one. Do I feel like I might have missed the law school experience, the camaraderie of other students, bouncing ideas, study groups, and so forth off of one another? Absolutely. It was a solitary type of position with the attorney that I did the 4-year clerkship under. But I was motivated. I had 2 young children at the time, and I was motivated to do it. And law school wasn't in my picture at the time. And so there are pros and cons. I feel like I could have, I would have perhaps preferred to maybe take some law school courses just for the experience of being in a law school auditorium, listening with other students for various types of courses and for the camaraderie. But I'm a self-motivated learner and always have been. So overall, it was a good experience for me, but I think there are pros and cons like there are with various alternative ways to learn.
Cool.
The second question, I'm sorry.
The cases you chose
cases,
and sort of
okay.
why
Okay.
you chose those 3.
Well, I can't say why I chose them other than 2 domestic cases. One was PR&R, parental rights and responsibilities, and property, just to show the committee the types of cases and the magnitude of what we deal with. It's not just simple, you get this car, I get that car, and I'll take the dog. These cases can be very fact intensive and require lots of time, not only listening to the facts and listening and running by the facts with the assistant judges, which I love doing because it's 2 other sets of ears and eyes that are there with me and sharing ideas when we're talking about fact finding, but it's also reducing it to writing. What do we find as credible and what do we find as not as credible? Because 2 parties can say the opposite thing and we have to figure out, well, who do we believe and on what points? And on one matter, there was significant school debt, college debt.
Yeah.
That one party incurred.
Which you didn't have because you didn't go to law school.
Not for that. I had it for college. True. You're right. I did not have it for law school, which is great, but there was significant debt. And I was thinking going into it, what do I do with this? And it came down to really going back through and listening, looking at the facts that we listened to and really digesting and dividing up the period of the marriage of when the schooling happened and for what amount of the educational loan was allotted to that period of time. And so I put that in there because that and then the property distribution and how we figure that out. I wanted the committee to know there's no exact science to it, and the Supreme Court has said that. It just needs to be equitable. It doesn't need to be equal. It needs to be equitable. And so there's a lot of discretion there that we exercise when doing it. And a lot of things factor in the length of the marriage, who brought the property into the marriage, what the value of the property is, who maintained the value of it or devalued it, if you will, damaged it. Lots of various factors that we look at under the statute. And so they're not easy cases. I really enjoy them because I love writing and I really love going back through the fact-finding process to get from A to Z. And then there's the PR&R. And in that case, parental rights and responsibilities, it was contested. we needed to figure out, the assistant judges and I, what was the best resolution for those children? There was domestic violence involved. And I'm not sure if that was included as part of the segment that I provided to you, but there was domestic violence involved that one of the children had witnessed, which is a huge factor for judges to consider in decision-making, because it's one of the factors in the statute that we need to consider, like what is best for this child. And so that was a huge factor in considering who should get parental rights responsibilities, but what the PCC should look like for the non-custodial parent. And this parent happened to be very close with the other child who hadn't seen any of the domestic violence, wasn't there that night, fortunately, and was actually very close to that child. So it was just to demonstrate the division of how parent-child contact can look based on the individual, because there's no rubber stamp for any divorce case or any case. We have to look at it all individual fact pattern and really figure out what's best based on what's before us. And there was no guardian ad litem in this case. It was the assistant judges and I figuring it out and, hearing the testimony of the parties. So that's why I included that one. The other one was a dismissal. Yeah, I just wanted to show the committee that despite being perhaps labeled or suggested that I may be prosecution-based or defense-based. In this case, I ruled in the defendant's favor, but I actually denied a Rule 12D motion, which is a motion to dismiss for lack of being able to demonstrate a prima facie case. There, I said, no, the state has enough evidence. So I denied it on that basis, and it was filed alternatively under alternative bases. But I granted it on the Rule 48, which is even wider spectrum for the interests of justice. And in that case, if I remember correctly, the person had already pled, had done a sentence, and then withdrew a plea subsequently, but had substantially done a portion of the sentence from the original plea agreement. And then we were back to square one after a substantial portion of the punishment probation had been satisfied. And so when it came back around and came before me as a Rule 48 motion to dismiss in the interest of justice, I found that it was in the interest of justice based on the age of the case, the things that the person had accomplished the first time around on probation, and that there wasn't a real legitimate reason to continue with prosecution, given that those two factors specifically. And there might have been others. I apologize if I don't remember every one, but I just thought it was important for the committee to know. I don't see myself as prosecution focused or defense focused. I look at each case, and I know others do, and I respect that. And again, it's my manual for reading. But I look at the case before me, on the facts before me, and I apply the law as best I can and decide it as best I can. So that was the reason for that. It may have seemed kind of like a trite case.
No, that's good. And then the final question about the concept of equal justice. So you're sort of more philosophical rather than WebEx and that kind of.
Well, yeah, no,
I
definitely.
know WebEx does have that there. That's about access to justice. I get it, but more philosophical
Right.
access to justice.
Absolutely. So I do think, as I stated earlier, I do think really equal access to justice would be having a drug treatment courts in every county of the state. Because a person up in the Northeast Kingdom, whether it's Caledonia or Orleans or Essex, that has severe substance use, opiate dependencies, mental health issues, that doesn't have access to a drug treatment court, when a person in another county that's been blessed with having one of those courts, that's not equal access to justice, in my opinion. And I know it could cost millions and millions of dollars to get one of these up and running, or two possibly, even if we had some counties, or I think one has a mental health court, which is also a real good thing to have, I think Chittenden. I know it would cost millions and millions of dollars, and it's a wonderful dream to have. But I really think if we want to have equal access to justice for all citizens, and many, many people in all the different courts that I've been in, but especially the juvenile and the criminal dockets, have substance abuse, alcohol dependency issues, mental health issues. And I really believe that offering a drug treatment court in each county, and I don't think it can be regional because I still don't think it's equal access enough, because people have transportation issues and there's homelessness issues. Each county, I think, would be the best way to address equal access for those types of needs. And I think they are in every single county that we have in Vermont. So I really support it. And I'm looking forward to doing the DUI treatment court tomorrow. It's my second time filling in and I really liked it. It was really a very pleasant experience and rewarding to have an interaction with persons that are in the court.
Thank
I
you.
hope that answers.
Yeah, absolutely. Thank you. I appreciate it in more detail.
Thank you, Chair. Hello.
Hello.
First of all, I think not going to law school and becoming a lawyer and achieving, becoming a judge is a really incredible accomplishment.
I'm not alone. There's
No,
many of us
no.
who've done it.
Yes, but I think it's noteworthy. And for what it's worth, I started in law school and left partly because it wasn't exactly a collegial environment. So maybe you didn't miss out on that much camaraderie. Depends where you go. I really appreciated one of in these comments, there's this one bit about an apparent switch in your demeanor, a change in your demeanor. And that to me, and this, the commenter says it's an unexplained change and a positive step in the right direction. And that to me, I don't know if that resonated with you, if you have any idea what they're talking about, but at least they sensed a change, which to me indicates an ability to accept and integrate feedback, which is really important. Of course, I'm assuming there was something that happened. I don't even know, but it might have been self-driven. To me, it doesn't matter, but that it was a perceptible change is noteworthy. That someone else perceived that change. And something that you were just talking about, not wearing your emotions on your sleeve and the need to be impartial is, priority number one. My question is, you also alluded to, or even mentioned in your letter, sleep deprivation and how acumen is often impacted by sleep deprivation. And I just wrote man, it's a really tough job. And I know I'm not saying everyone in here knows this, but we should say it every chance we get. Being a judge is a really, really tough job. And I'm thinking about you trying to be impartial and perhaps missing out on moments to experience your own humanity and how those moments can positively impact the people in your courtroom. And I wonder if you ever think about that and how you can take care of yourself. We can't be completely shut off. I know you must have learned how to compartmentalize and things like that, but I think about what I learned as a mom when my kids were really little and there's mom guilt all the time. And then the people who would say to me, you need to take care of yourself because your kids will feel it if you're not.
Right.
And I wonder if there's anything like that going on for you in the courtroom where even the people coming before you might benefit from you letting yourself feel a little bit more. If you are able to do that, of course, you have to take care of yourself, but it's a difficult balance. I wonder if you can say anything about that.
It is a difficult balance, but I try to take care of myself in my personal life by, engaging in positive pro-social activities to exercise body, mind, and spirit. And I do it almost daily. I love family activities and events and exercise and things like that. I don't wear my emotions on my sleeve, but I do show some emotion from time to time when it's less visible as showing bias. For instance, in the matter that I talked about in my statement with this family court matter that I had where a parent became tearful, I was smiling at the parent saying, "You've been doing a great job." I don't usually smile in criminal court unless, there's some levity in the courtroom because it's a very ominous, somber experience and we're there for a potential crime and so forth. But I do allow myself when the occasion permits to smile and to, break through the serious look I have. It worked as a parent, I'll tell you. But I do allow myself to break through from time to time when the when is the appropriate time? I didn't always feel like it was in a criminal courtroom as much because of, the accused being there and perhaps a victim in the courtroom and competing interests, prosecution and defense, and very serious allegations. So levity wasn't as, I wasn't as open to it there, but in a domestic case, I will frequently talk to the parties and say to them, I know you don't love each other anymore. That's very obvious. We're here. But you have two beautiful children and they love you and they love you and you love them. That is very clear. And I really try to humanize myself to them to say, I know you don't love each other. That's why we're all here. But I try to find the right audience for it, if that makes sense. And occasionally in juvenile court, I do have the right audience. I love it when I see success stories in juvenile court, especially because those are heart-wrenching cases when we've taken kids and put them into custody and parents are struggling with any penumbra of things that we've talked about. And they're having some success. I really like to acknowledge it because some of these people haven't ever had a cheerleader in their life ever. And when they hear it, they love it. And that makes me feel good. If that makes sense. I hope that
yeah.
addresses it. But I take care of myself outside of court and I just don't feel like I can across the board show too much emotion in court.
Yeah.
Thank you.
Thank you.
Thank you.
In the chair's discretion, I've let things go we're a little bit behind time. I hope no one objects because it's just love another.
We're just gonna have more cookies.
It's gonna take time.
John, you start.
Right here in front of me, Mr. Chair. You want
Thank you.
anyone?
Also, thank you.
I'll take one.
Yeah, take the whole thing. See if they want.
Really?
And we'll hear from Magistrate Barry Peters.
Good evening. As you know, my name is Barry Peterson. I was appointed to be a magistrate judge 12 years ago, and before that, I was in private practice with my wife for 27 years. I sincerely hope that you'll retain me in my current position as magistrate judge. My job is very different than the two Superior Court judges that come before you. I spend most of my time establishing, modifying, and enforcing child support and medical support obligations. I work primarily in Chittenden, Franklin, Lamoille, and Grand Isle County, and right now temporarily in Windsor, doing child support. And I rotate on a daily basis each day of the week. I'm usually in a different court unless I'm in one court 2 days of that week. I enjoy the work that I do, and I'm keenly aware of the responsibility that the governor and the nominating committee entrusted to me. I believe I'm making a positive impact on the parents that come before me and their children. I am pleased that all the attorneys and judicial assistants who answered the retention survey support my retention. There are many times that one parent or the other may not be completely happy with my decisions, as related by the other judges. But I always want to make sure that each litigant that leaves my courtroom understands and feels that they have been completely heard and they understand the reasons for my decisions. I've also been especially assigned to do divorces and other domestic matters, which you've seen in my writing samples. If the parties cannot reach an agreement or a stipulation, then I need to make decisions that I believe are fair and equitable as between the parents and what are in the children's best interest. I have also been assigned to hear relief from abuse complaints. One of the biggest challenges of my position, as also related by the two Superior Court judges, is time restraint. I hear between 40 and 50 cases a week. Most weeks, the vast majority of the parents that come before me are unrepresented. They appear pro se. Therefore, it's particularly important that I make it very clear to the litigants that come before me certain things. I commence each hearing by exploring the possibility of reaching a stipulation or an agreement on any of the outstanding issues. I emphasize to them that reaching an agreement is usually better as they know the details and circumstances of their lives and their children's lives. I listen carefully to what each parent has to say, and always treat everyone with respect and ensure them of my neutrality and my lack of bias towards either party. There are many times that I need to demonstrate compassion and understanding equally to both parties. Divorces are very stressful to parents and very stressful, particularly to their children. If appropriate, I always remind parents of the impact divorce can have on their children, as children are also under stress and they do not have the adult tools to deal with it. I issue all my decisions in a timely fashion, knowing that any delay in my decision can only result in added stress to the family. As you are aware, judges and magistrates get very little feedback on how we are doing and how we are being perceived by litigants and their attorneys. I really appreciate receiving these retention surveys. In reviewing the retention surveys, there were a couple of respondents that felt that I was somewhat biased to female parents who are unemployed or underemployed, and that I lecture or are condescending to the parties. I need to make decisions by statute that are fair to the custodial parent, fair to the non-custodial parent, and fair to the children. If one parent decides to be voluntarily or underemployed, I usually impute income to that party, taking into consideration the potential cost of childcare. As you are aware, most parents of modest means in Vermont can qualify for childcare subsidy. In one of my writing samples, before I knew the responses to my surveys, I had actually imputed full-time wages to a father who was voluntarily underemployed. I need to consider all the evidence presented to the court, applying the evidence to the statutory factors. I'm working on doing a better job of explaining to the parties my findings of fact and all the factors that I have considered before making my decisions. That is always a constant work in progress. Unfortunately, parents frequently involve their children in their divorces, believing that somehow this is going to gain them some sort of advantage. If I sense a party is involving their children in their divorce, I encourage both parties to not say anything negative about the other party in front of their children, and don't allow loyal friends or family members to say anything negative about the other party in front of their children, as I'm sure their children just want to love mom and love dad and not get involved in these adult disputes. I also point out the negative impacts that such behavior the parents can have on their children long term. This statement usually results in one or both of the parents nodding their head, and sometimes I get the pointing finger from one of the litigants towards the other. I thank you for your consideration. I hope that I get retained in my current position.
Many, many years ago, my then 11-year-old son said to me, when you say something mean about your ex-wife, you're talking about my mother, and I want you to stop. And I promised him I would. 2 years later, I said something mean about his mother. That he made a promise to me. So, well, you're absolutely right about that. You got rave reviews, and you got a lot of very positive stuff. So there's only a couple, and you've already talked about the two negative comments I noticed, and it seems crazy to focus on these, but that's all there is. Otherwise, I just say congratulations.
I appreciate that.
Good comments. That you were hard on pro se litigants. That you appeared impatient and annoyed, and the other one was a lack of sympathy towards at least one single mother.
Right. So that's what I was referring to.
Yeah.
I am very serious about making sure that I am constantly improving in my work. And it's very difficult when we receive these comments because they lack specificity, and they necessarily lack specificity because I think the sense is that if they are too specific in what was actually said, you're going to be able to track down who the attorney was or who the judicial assistant is. But it gets difficult to respond to those sort of negative comments But in seeing that, I am going to take a look at some of my past hearings that I feel were more adversarial and see if what my perception is, how I'm being perceived, as opposed to how I believe I'm being perceived. And that's why I do appreciate this phone.
When I was a teacher and we got reviewed by our students, I could pretty much tell who every negative comment came from. Oh, yeah, I remember that. Okay, we'll start with Representative Arsenault and we'll go counterclockwise this.
Yep. Nice to meet you. As has been said, the feedback was uniformly positive, and what I'm thinking about is this really unique, important window you have into the family lives of Vermonters. And I'm wondering if you can share with us anything that you've observed or learned about where we are failing people, where we are failing to support families, and what we might do better.
As far
As
the
a
state is
state,
concerned,
as
or
a
the judiciary.
culture, as a state,
Also,
as a
universal
culture,
question.
as a society. I just think you have such a unique view. I would think that you've learned a lot and been able to observe a lot. And I wonder if there are patterns you see, or, like where is the breakdown in Vermont families? Or the top 5, it's a very broad question, but I just want to take advantage of what all this information you have in your brain.
I would say that I frequently come away from my hearings believing that some children raised in such non-supportive environments are pretty much from the get-go being raised with 2 strikes against them. And that children that come from supportive families have really a leg up. And as far as support of identifying those children that perhaps have those 2 strikes against them as early as possible, preschool or elementary school, perhaps the support could be improved for those children to hopefully try to balance, to equalize the lack of support that they receive at home. As I'm sure you have all heard, I've heard horrendous things that happen at home. I don't do juvenile work, but I see it in the divorces and abuse and domestic violence and relief from abuse hearings. I used to say to my wife that my wife is also an attorney, she's a real estate attorney, or I was an attorney. Before we became attorneys, we thought that perhaps this was the worst people treated each other. But then after you become an attorney, and particularly after you become a judge, you realize it's really down there, how bad some people treat each other. And I'm always focused, of course, I have to focus on the litigants and the parents, but I find that the true victims in a lot of these circumstances are the children. And they're the ones that need that support, and whatever we can do, get that support in place as early as possible. Perhaps can help them break the cycle, perhaps, of whatever it is, addiction, poverty, abuse, because unfortunately you do see a lot of repetition going on. I'll hear evidence that he was treated this way as a child, and this is the way he's treating his spouse and his children as an adult, and maybe even grandpa was involved, or grandma. It's goes both ways. So, sorry, I didn't have more.
No, it's not something that I would expect like a
Treatise.
You did great. Yeah, it's a very broad question, but again, I just appreciate your position and the experience you have and the stories you've heard, and stories are important and can be very informative. So thank you.
Thank you. Hi, this is for you. This is your 3rd return.
As with Judge Treadwell, it's my 3rd, but my first was I had not actually even been confirmed.
Oh, geez.
I had not sat on the bench yet. And I had come up for retention. I don't think either of us got an actual pass because the committee wanted something from us.
Yeah.
And so they asked me to provide some writings that an attorney have something.
Right.
But this is, I would say, my second real one. So I've been here 12 years.
Okay, okay. Well, I have, just one comment and two comments maybe and a question. One is this, child support order that you included. There are things that should have been redacted on it before you submitted it.
Oh,
Yeah,
I
so,
apologize.
yeah.
What do you see that?
Social security numbers.
Oh, geez.
Yeah, so just
Oh, I'm sorry.
caught my eye and I just mentioned it to our,
So is that a public document?
I think,
It is, but in status right now, we have the opportunity to redact it now, so it's not
Okay.
online or anything like that, we're just in the volumes that we have in front of us, so I'm gonna.
I apologize.
Sorry.
That was a complete oversight on my part. The reason I gave that to you is that's the form that I am required to put my child support orders on. And so that's why I wanted you to see at least.
yeah,
one
no, it's
example.
helpful to see what you have to work with. I just noted that, and it happened a couple of years ago too with a different judge, so
I apologize.
I just
I'll be more.
careful of the information. So my one little question, and then I have a bigger question, is I was looking at your list of courses you've taken.
Sure.
And last year you took one on the climate change effects on the courts.
Right.
And I'm curious, could you say more about what that entails? That's fascinating.
It was a general course having to do with floods and impact of flooding about as you explained.
Yeah, it was in
Here
March of
Montclair.
23, so that was like prescient that you
Right.
back to you.
Yeah, and so it had to do with that, it had to do with those sort of impacts, the impacts of drought and the impact of flooding.
So not specifically on your.
No, not on the building itself or on my ability to.
But so the impact on the people who might be coming before you?
Right.
Okay. And I'm sure.
That's my recollection.
I'm sure during the floods, there was more stress on families.
Oh, yeah.
Probably.
Very much so.
Or-
But we kind of got a double hit.
Yeah, I think so.
6 months apart, we had two 50 or 100-year floods.
Yeah, it's crazy. But my bigger question was similar to what I asked Judge Warren. Is your concept of equal justice, your answer was pretty brief. And I was wondering if you could expound on it and provide a more sort of philosophical or what's your philosophy of equal justice that you apply in your work?
Access. It has to do with access. I was initially very skeptical of WebEx hearings, but I have come around to believing that WebEx, particularly in the child support arena, is preferential.
Mhm.
Because in child support, I frequently have the only person showing up is the custodial parent who has had to take time off from work only to appear in court and find out once again, the non-custodial parent has failed to appear and in addition is not paying their child support. And in addition, she or he gets docked pay.
Yeah.
Okay. And so I allow in all my courts, and most of my child support hearings are less than a year, it fits within the guidelines. I allow hybrid, that if people want to appear in person, they're welcome to appear in person. If people want to appear via WebEx, they're welcome to appear via WebEx. When you get into lengthy domestic hearings, though, I would want an assurance. I've had lengthy domestic hearings shortly after the pandemic by WebEx, but you just have to make sure that everybody is aware of the ground rules, that they have to have a very good connection, that there has to be a video feed that clearly shows an accurate depiction of themselves. And also, as pointed out by the other judges, I think it's always very important that no matter what I do as far as a WebEx hearing, is that I ask what papers are in front of you that you might be referring to that we should be aware of. And also, is there someone else in the room with you? Because you frequently all of a sudden will hear someone testifying and then you hear this voice.
Coaching.
And it's the new girlfriend or the new boyfriend or the new husband. Just a quick funny story, and I know we're running late here. I had one gentleman testify, there's no one in the room with me. Absolutely no one. I said, very good, sir. I just want to make sure that's something I covered at the outset of every hearing. And then all of a sudden, the hearing goes on for about 15 minutes. And then I see his wife crawling on the floor out and going outside into the hall. Yeah. Yeah.
You might be
The
skeptical.
WebEx challenge
Yes.
definitely undermined his credibility.
Yes, okay, interesting. After doing this for so many years, do you still feel fresh with it? Like you're not burnt?
No, I'm not.
Okay.
I did.
You don't seem like you are. I'm just
People are-
curious.
I would say most attorneys and most judges don't relish doing domestic work. I would say that's kind of my perception, but I really do enjoy it because as I said, I keep an eye on the children. Along with the parents and what is in their best interest. I'm very sensitive to abuse or intimidation or control issues between the parties and the effect that can have on their relationship and particularly the relationship with their children. So no, I still quite enjoy this immensely.
Cool. Thank you.
Thank you.
Thank you.
Yeah.
Thanks for everything that you've shared with us this evening. I did have one question. You seem like you're almost like a natural educator, and I had written, do you believe that part of your job is to educate or help rehabilitate those who come before you in court? And if so, how do you do that?
I don't have a lot of that in my court because I don't do drug court. I don't do criminal. I don't do juvenile. Okay. As far as I do have addiction issues, alcohol issues, and at times we have a discussion on whether those are issues that perhaps I would encourage the parties to address, and that if, as represented by my colleagues, I have a circumstance as of today. Gentleman was very proud to tell me, and I didn't even ask, I was about ready to wrap up the hearing, said, I just wanted to let you know, Your Honor, that I've been sober for 1.5 years. And I commended him on that, and this is kind of where the compassion and understanding comes in. I commended him on that, and I said, not only have you improved yourself, but you've improved yourself for the benefit of your children, and you've demonstrated to your children something that perhaps is I don't want to say normal, but you perhaps have taught your children a lesson that you found yourself in this situation, in this problem, and you addressed it and pulled yourself out of it. And you have become perhaps an even better role model for your children than somebody that just has carried along without ever having an addiction issue or any other challenges.
Hearing that? Great.
So, Judge, I'm with Senator McCormick. You know, your remarks are all great. Your comments are good. You addressed whatever comments that were other than excellent. And I don't really have any questions. Thanks for coming tonight and keep up the good work.
Thank you.
Thank you, Mr. Chair. Congratulations on your 2 shutouts.
Thank you.
One of the things in your letter to the Secretary of State that resonated with me was that you feel strongly that it's important to continually be updating and expanding your knowledge of the law, the legal process, and gaining insights into where the people who appear in front of you are coming from.
Right.
And you mentioned that most of us have a privileged, stable, and supportive upbringing, and it's important for us to try to comprehend those that may not be in that particular situation. I think that's a great lesson for everybody. It's a tough lesson for many of us to admit that we are in that situation. So I'm wondering, are you constantly, the people that are coming before you, trying your best not to take perhaps their appearance
Oh, absolutely.
or anything else? So you can come back and forth. Because I would think that can be tough to do. It's tough to do in this building. And, you know, we all try our best, but sometimes we don't do very well with it.
Well, you're exactly right. Someone showing up with a tank top and tattoos, you might jump to some conclusions in that regard. As far as understanding people that have come from different backgrounds, this is something that I have also relayed to my children. I have two children, they're both adults, they're both in their thirties. That you have to appreciate that when myself and my wife and they went out into the world and decided to embark on some endeavor and perhaps take some sort of a risk, such as perhaps going to school or entering into a job that was not going to be paying them very much money with hope of earning more money in the future, or whatever it might be, is that they were able to go out into the world knowing that no matter what happened to them, they would be always able to come back and land on their parents. And that would be as far as they would be allowed to slip. Whereas a lot of people from less financial secure situations are less inclined, perhaps, to do such things as to go to school full-time for college or risk starting a business, knowing that if they failed, they're going to end up homeless. And that's a just distinct advantage to where I grew up, my wife grew up, and our children grew up. And that's something I'm constantly trying to make sure I understand, that there might be reasons that are not immediately obvious as to why this behavior is occurring.
Thank you for reminding us.
Oh, no, I'm sure I don't have to go there.
Thanks for jumping back into the fray. There. From everything that I've witnessed in the courtrooms, with you it's been really great. Interactions with staff and then, in the lunchroom and in the clerk's office and in the courtroom, it's all been good. I'll ask you this stuff. Impatient with pro se clients.
Yeah, that was an issue. That's something that that's one of the things I'm going to look back. All the hearings are recorded. I'm able to just access those. And I want to look through those to see what the perception might be. That was a somewhat isolated.
Right. And well, it kind of goes back to something Senator mentioned a minute ago about having to teach and so on and so forth and educate. Pro se clients don't know what they're doing necessarily in a legal hearing. So you're then having to educate them through the hearing, yet still sort of, maintain control of law.
Well, I also point out, like, for instance, on the child support arena, it frequently happens. I don't understand why I have to pay child support because I never see my children. I said, well, these are two separate issues. If you feel that there's a parent-child contact order that's not being complied with, you need to file a motion to enforce. If you feel that there's been a real substantial unanticipated change of circumstances, you can file a motion to modify, to gain more contact with your children or some contact. But I would say there are a lot of people in Vermont that pay child support that never see their children. And then because of financial circumstances, there are a lot of people in Vermont that see their children all the time and don't pay any child support. And that's,
Thank you.
You're welcome.
We done?
I think so.
Thank you.
Thank you.
Thank you. There will be a public hearing in this room next Wednesday, not Thursday, next Wednesday at 7:00.
Thank you for your time.
Yes.
Thank you.
We can adjourn now.